My name is Lisa Nyuli. I'm a partner in the firm of Ariano, Ritt, Nyuli, Richmond, Lytle, and Goettel. I've been in practice for 28 years. Today I'm going to give you some tips on planning in advance in the case of your sudden disability or death. While retirement is usually planned and handled in an orderly fashion, sudden disability or death is usually an exercise in contingency planning. Instead of having time and options, decisions need to be made in a speedy fashion and are frequently forced by the circumstances. Currently, Supreme Court Rule 776 allows the Circuit Court to appoint a receiver when it comes to the court's attention that an attorney in the circuit has been unable to properly discharge responsibilities to their clients due to disability, disappearance, or death, if there is no partner, associate, executor, or other responsible party capable of conducting the lawyer's affairs. Obviously, appointment of a receiver should be a last resort, and sole practitioners should take steps to have or to name a substitute attorney. The Illinois Rules of Professional Conduct, Rule 1.3 Diligence, instructs sole practitioners to have a contingency plan in place and as set forth in Comment 5, to prevent the negligence of client matters in the event of a sole practitioner's death or disability, the duty of diligence may require the preparation of a plan that designates another competent lawyer to review client files, notify each client of the lawyer's death or disability, and determine whether there is a need for immediate protective action. What should your plan look like? You should make lists. The first type of list would be a client and client information list. It should contain the names, addresses, phone numbers, and email addresses for your clients, indicate how open files are organized, indicate how closed files are organized and stored. It should contain retainer and engagement agreements for each matter. You should have copies of billing statements and full client accounting ledgers and history. There should be calendar and task lists for every matter and designate the status of each matter. Considering your digital assets, look at your email accounts and list them out. Consider your practice management accounts, the billing and accounting systems you may have online. Look at social media accounts, your website domain, your password manager programs or websites. Consider your online banking websites, payroll websites, credit card websites, bar association websites, and legal research websites. You need to give your successor information on how to access these accounts. This would include login IDs, usernames, passwords, and security questions. For your firm files and records, make sure to provide your FEIN number, your state of Illinois account numbers, provide copies of federal and state tax returns with supporting documents, your 941 returns, your unemployment information, any employer benefit plans you may have, which could be insurance or retirement accounts. If you have corporate documents, consider who has keys and identify those people. Leave instructions for voicemail access. Identify any PO boxes. Any bank account information should also be provided. This would include bank names and addresses, contact people, account numbers, who authorized signers are, credit card information, and identify where all safe deposit boxes are, and indicate who has access to those boxes. Provide your payroll information and accountant information. Also leave information regarding your insurance policies and any vendor agreements that you have. For your attorney trust accounts, keep detailed records of all deposits and withdrawals, keep reconciliation reports, keep client and matter balances for each client and for each trust account. Now, what about the attorney you designate? Who should this person be? Once you choose someone, you should have a written agreement with that attorney outlining their responsibilities. Things to consider would include whether this person should be your personal attorney. You should have a signed consent authorizing the attorney to contact clients for instructions, for transferring files, for obtaining extensions of time, and acting on their behalf. Bank authorizations to sign on general, operating, or trust accounts should be provided, and consider when access should be granted. Should it be given for all times, specific times, or the happening of a specific event? Inform your staff and your spouse of the agreement and the designated attorney's contact information. You may want to update any retainer agreements to include information regarding the designated attorney. The attorney you choose should also have malpractice insurance. While this sounds like a lot, these points are really just the basic considerations and should be the minimum of objectives in a succession or an emergency plan. Fortunately, the ISBA is here to help as well. On the ISBA website, go to Practice HQ, and you will find a wealth of information from checklists to form documents to articles and CLEs to get you started in your planning. Take advantage of these tools today. Don't get caught without a plan.